Mr. Speaker, members, so everybody knows this is a standard amendment that basically kills the bill. It's called an enacting clause. So if you haven't been through this, this is just basically an amendment that kills the bill. And so I know you're going to be shocked, but I'm not going to be in favor of this particular amendment.
Mr. Spiller, for what purpose?
Yes, will the gentleman yield for questions?
Mr. Hunter, would you yield?
Absolutely.
He will.
Thank you. Mr. Chairman. There's been some discussion, in fact, on this amendment relative to the Petaway case and coalition districts. I want to ask you, you've already mentioned the Petaway case in your layout, and that was the August 1st, 2024 case that the Fifth Circuit ruled, Petaway versus Galveston County, where it said that coalition claims do not comport with Section 2 of the Voting Rights Act of 1965. Is that correct?
That's correct.
And in short, so that we've heard a lot of discussion about opportunity districts and so forth, but coalition districts are the subject of the Petaway case, and coalition districts are generally defined, is it your understanding, of districts that don't have one particular minority group that make up a majority of the district, but one or more of those minority groups are combined together or aggregated to reach a majority. Is that a fair definition? Correct. Okay. And you touched on it before in your layout, and I know we were short on time, but under the current district, under the current congressional maps that we're under right now, not HB4, but what we're currently under, there are coalition districts that were created as such in 21 because of the law as it existed in Texas under the Fifth Circuit at that time. Is that a fair statement?
That is correct, in 2020.
Right. And then, in fact, that law that was in place when these districts were created under 21 was the Compost versus City of Baytown case, which is a 37-year-old case, but it was the law, not necessarily throughout the country, but it was the law in the state of Texas because it was the law in the Fifth Circuit. That was the precedent. Is that correct?
In Petaway, they referenced it, and that's what they said.
Okay. So now in Texas, one of the reasons that we're doing this now is that we feel compelled to because of the Petaway case and the ruling in the Petaway case as it relates to these coalition districts, correct?
Well, I think it's a combination, Mr. Spiller. I think you have a U.S. Supreme Court Rucho. You have a Fifth Circuit Petaway. The combination of both those cases are involved in this map.
Right. And you mentioned also in the Rucho case that is a U.S. Supreme Court case that allows for partisan performance. And in fact, in that case, I think there were competing claims, whether or not there was Republican claims, Democrat claims, multiple issues there, and the court said, we're not going to get into that. Partisan performance is absolutely okay, and we authorize that.
Yes. So the members know the U.S. Supreme Court considered two states, one Republican that were redistricting to reduce Democrat, gain Republican, then one state Democrat that wanted to reduce Republican, one who had been there 20 years. And the U.S. Supreme Court said that is not the judicial purview, and political performance is a criteria.
And we know that political performance can be done, and in fact has been done in other states already. Is that correct?
Absolutely.
In fact, there are some states that are Democrat-controlled states, Democrat majority, some of which are the favorite vacation spots of certain people in this room, that whether it be California, New York, Illinois, New Jersey, Maryland, Massachusetts, that have already done this to a fairly extreme degree. Would that be a fair statement?
That is true. I mean, this is not unique. That's why the courts have addressed it. And both parties that you referenced have been involved.
There's been some discussion recently about some of the districts in and around Harris County, and I just want to ask you briefly on some of those. We talked about District 18, what we call the Barbara Jordan Historic District. When we went to Houston, we heard a lot of testimony about that, but it was under HB4, it's currently one of these coalition districts, and under HB4 changes to a majority black CVAP district. Is that correct?
That is correct. It is now 50.71% black CVAP. In 2021, it was 38.99% black CVAP.
And so previously, black voters in that district did not hold a majority, but under your bill, under HB4, they actually do. Is that correct?
That is correct.
All right. And we also heard a lot about compactness, and you think that's what you've done generally with HB4, but specifically in Harris County as well, dealt with that issue of compactness. Can you touch on that?
Yes, you know, even though public hearings may have opposition or support, we heard from public in those hearings about the compactness issue. And one of the issues was the Austin to San Antonio district and why they felt that should be looked at. Same thing in Houston. They looked at 18 to the original rather than how it has spread out over the years. So yes, compactness has been involved.
Okay. And also, in relative to Harris County, we talked about District 9, which was also second one in Harris County, a coalition district, and the district that was addressed in the Petaway case, and now under your HB4, changed from a coalition district to a majority Hispanic CVAP district. Is that correct?
Yes, for the record, the Hispanic CVAP of Congressional District 9 under this plan, the Hispanic CVAP is 50.15%. In 2021, it was 25.73%.
All right, and I'm trying to move quickly, but on District 29, one of the other districts out of Harris County, we've heard some testimony or some questions about that today. We heard testimony about it in the committee, but it went from a majority Hispanic CVAP district to a majority Hispanic VAP district, but is it a fair statement that it should continue to perform as a Democrat district?
Let me give you the information on 29, because I just heard some of that so that everybody knows. 29 has gone from a black CVAP in 18.31% in 2021 to now 32.79%. As they said, Hispanic CVAP decreased, but to 43.12%. So you basically have Hispanic black percentage that is plus 70. The other note is that the political performance in 29 stays Democrat.
Right. And likewise, the other district I want to talk about in Harris County was District 7. We heard quite a bit of testimony regarding District 7 in the committee, and it was a very diverse district, but I think it remains a very diverse district, and I think also continues to be Democrat. It has a Democrat representative, Congresswoman. I think it will continue to perform Democrat in that district. Is that correct?
Yeah, the data on 7 is that it has increased slightly more Democrat performance. The other characteristics do not change, but under 7, if you look at the new numbers, they're very, very close to what they were.
All right. And this claim that a lot of this stuff is racially motivated and race negative, let me ask you, and you've touched on it before, but we went under the current map from 0 majority black CVAP districts in the state of Texas, and now under your map, we added 2 to that list where there are 2 majority black CVAP districts, correct?
Correct, 18, and is one of the ones that we talked about in 30.
And under the current map, we have 7 majority Hispanic CVAP districts, and that is increased under HB4, under your bill, to 8. So we're adding one more majority Hispanic CVAP district,
Yeah,
correct?
majority Hispanic VAP districts in
The gentleman's time has expired.
Mr. Speaker.